Hello, hi. Welcome back to another video recording. And today I want to do a video recording on the topic of mistake in relation to contract law. And mistake is something which may arise sometimes in contracting, where one or both parties might have made a mistake in a contract. And say for purposes of even an examination within the law of contract examination, it is a fairly popular exam area where the examiner would want to examine students to see whether or not are they able to identify the different types of mistakes that has arisen and what would be the possible effect of mistake on the respective contracts. And so allow me now to share my screen on some materials I prepared for you this short session where we want to talk about mistake. As a starting point, I think it's good for us to understand that mistake in law, operative mistake, is different from mistake in the normal, ordinary English sense of how we might use the word, because mistake in law has a legal effect of making a contract void, where the contract will then be regarded or treated as if that it was never made. The contract is void. In other words, it is not just that because of mistake that a contract is not valid. Rather, because of mistake, the contract was never valid at all from the beginning, hence the use of the word void. And so practically speaking, this would mean to say that the contracting parties will then be put back to their original positions as if the contract was never made. In the case of a contract for sale of goods, the buyer who has paid for the goods would then be able to claim a full refund to get back the purchase price he has given. Similarly, in the case of a seller, he would be able to get back the goods that he has sold on mistake. The parties respectively will be restored to their original positions. A very practical area or use of this area of mistake or doctrine of mistake is where frequently it is used as a defense but for breach of contract. So for instance, here could be a case of a seller who might have sold goods to a buyer, and it may be the seller discovers that he has made that sale and had wrongly put up the price. Maybe the goods could cost $10,000, but by mistake he has put it at $1,000, and it's a mistake. But that particular buyer might have already placed an order for the goods. So if the seller had sold the goods at $10,000 and the buyer had said, okay, I accept to buy your goods at $1,000, with the presence of offer and acceptance, there would be an agreement. Assuming the other requirements for formation of contract is also satisfied, then there will now be a contract. But surely the seller would not want to be bound to the contract that had been formed, and so he will argue mistake and raise it as a defense. So he will not perhaps deliver the goods. The buyer may wish to sue for breach of the agreement, claiming that he has placed an order, perhaps even had given a deposit, and the buyer would insist that the goods are delivered, otherwise he will sue for breach of contract. And that is where the buyer will then want to argue mistake as a defense, to saying that, well, I made a mistake. The goods are actually not $10,000, but it's $1,000. And so because of the mistake, and assuming that the rules for legal mistake, they are satisfied, we've seen this, and it's your first point on your screen, mistake voids a contract. And so if that contract is now voided, there's no contract, then the buyer cannot be suing for breach of contract, can he? And so that's how a seller, in this instance, can argue mistake to void the contract, and accordingly the buyer will not be able to sue because effectively we will treat this situation as if that no contract was ever made. It's void. Part of what makes this area complicating, as I began earlier on, was where I said to you that there are all these different types or categories of mistake. Bilateral mutual mistake, bilateral common mistake, and you'll see that even for bilateral common mistake, there are 3 types of bilateral common mistake. And of course, you have your unilateral mistake, and then even then, you have your 2 different types of unilateral mistakes. So how then do we identify or relate this, practically speaking, to scenarios, and when is it one type of mistake as opposed to the other? And I am now showing you a past exam question from the University of London, and you might have seen this question before, and it's a great question that allows me now to illustrate for you all the different types of mistakes that would arise that we could see within this question. If you have not seen this question before, please pause the video and take a few seconds or minutes to try to identify for parts A, B, C, D, E, what type of mistake would this be? Now, if you have gone through the question, let's just now run through this and very briefly try to look at each part, A, B, C, D, E, and to see whether or not it falls within which category of mistake. As a useful guide, whenever you look at an exam question like this, in relation to mistake, the first thing that you want to do is to see whether or not is this a mistake made by one party or 2 parties. That being the distinction between whether or not is it a unilateral mistake or a bilateral mistake. And with that, we can then look deeper to see within that unilateral or bilateral mistake, what specific type of mistake is this? And it's only when a student is able to identify the type of mistake, then along with it will then come the relevant discussion to ensue, the appropriate cases, the principles, and then to come to a conclusion. And so this is an important starting point to identifying the issues and the type of mistake. Let's look at part A. So here Jane intends to buy a laptop computer that Ahmad was using when he made the offer. And so Ahmad was saying to Jane in your first paragraph, would you like to buy my computer for 300? So Jane intends to buy. And so, however, we now see in part A that there is this mistake made, that Jane intends to buy the laptop computer, but Ahmad is intending to sell instead the old desktop computer. The offer made by Ahmad to Jane arguably is ambiguous, because all that was said is that I want to sell you my computer. But we know that a computer could be in relation to either meaning a laptop or a desktop. So that's where now a mistake has arisen in part A. So let's look at part A and ask, is this a mistake made by one party or 2 parties? Is it a case of where Ahmad knows that Jane was mistaken and he was not? Or that Jane knew that Ahmad was mistaken and she was not? Or is it a case of where it's a genuine mistake made by both parties, that Ahmad says, would you like to buy my computer? In his mind, he was referring to his desktop, but Jane thought it was a laptop, and hence, therefore, that's why it's a mistake that is made by both parties. And I think that you are right in your assessment that this is a bilateral mistake. Bilateral being the word that we use in relation to a mistake that's being made by both parties. Now, where it's a bilateral mistake, you can now see that there are these 4 categories of bilateral mistake. It could be mutual. It could be as to existence. It could be as to ownership or as to quality. So in part A, one party is buying a laptop, the other party is selling a desktop. What bilateral mistake would this be? And this would be bilateral mutual mistake, which is also known as a cross-purpose mistake. We are both mutually mistaken. I thought that I am selling you a desktop. You thought that you are buying a laptop. We are both mistaken, that's bilateral, and it's mutual because we are both mistaken as to a different aspect of the subject matter. And the computer could mean this or that. We are both mutually, respectively mistaken. That's part A. Part B. We are now told of Ahmad, where English is not his first language and is often confused with the words 3 and 9. And crucially is this next part, which I would like to draw to attention, is where we are told of how Jane realizes that Ahmad has probably made a mistake. This is a crucial part for part B that allows you now to straight away identify that Jane is not the one mistaken. Jane knows that Ahmad is the one who's mistaken. And so therefore, in other words, this is a mistake made only by one party. And so it's a unilateral mistake. In that, when Ahmad was mentioning 300, because English was not his first language, he actually meant 900 instead. So he was mistaken with his 3 and 9. And Jane knew that. And straight away you know that this is a mistake made by one party. It's a unilateral mistake. And within unilateral, you come down to the last two boxes. It's either a mistake as to identity of the parties or as to terms. So clearly this is nothing to do with identity of the parties. It's a mistaken term. That Ahmad was selling the computer, believing that or wanting to sell at 900, but it's a mistaken term because it said 300 instead. Right? So this would be mistake. Now let's look at now part C. And to identify what type of mistake this is, Ahmad thinks that his mother had bought him a new computer as a birthday present. And that's why in the first paragraph we are told that he's now selling the computer. But in fact, we are then told in part C that she has instead bought him a new television. In other words, he does not have that new computer to sell as he thought he could, which he was doing when he offered to Jane, saying, would you like to buy my computer for 300? Now, so again, when you look at this, you would already see that this involves the issue of existence of goods. In that Ahmad is selling something that he thinks he has, a computer, but in fact, he does not have a computer. It's a mistake as to existence of goods. And in your types of mistake, there's only one category that is as to existence, and that is here, a bilateral common mistake as to existence of the subject matter of the contract, that is, the new computer does not exist. Now, this is bilateral as opposed to unilateral because this is a mistake made also by both parties. In that Jane, the other contracting party, would have no idea of knowing that Ahmad would not be getting a new computer. Because Jane would probably also believe that Ahmad has that computer for sale. Jane would not know that Ahmad does not have that new computer for sale. And so it's a mistake made by both parties as to the existence. Ahmad was selling what he thought he would have as a new computer. Jane took it as face value and assumed that Ahmad would have a computer for sale. But in truth, that computer never existed because the mother bought Ahmad instead a new television. So that's a bilateral common mistake as to existence. The last category, or rather the second last category or question, part D, is where, unknown to Ahmad, his only computer was destroyed in a gas explosion at his home, which took place 1 hour before his conversation with Jane, which is before this conversation where he was offering to sell the computer to Jane for 300. So he never knew. So the picture you are seeing, and it may help if you were to draw it out perhaps, but the picture you're seeing here is that Ahmad is now offering to sell his computer for 300 to Jane, but unknown to him, his computer had been destroyed. He really has no computer available for sale because it had exploded 1 hour before. But yet now he's going to offer to Jane and says, would you like to buy my computer for 300? So he's mistaken as to, that's right, existence. In fact, this part D is quite easy to spot or identify because you're seeing a case of that the item, subject matter of the contract had been destroyed, had perished, does not exist by the time of the contract of sale. And so very clearly, if the subject matter of the contract, i.e. the computer, no longer exists at the time of sale, then therefore it's a mistake as to existence. And again, it's also clearly bilateral as opposed to unilateral because definitely Jane would not also be aware of this. Ahmad is selling the computer. Jane says, okay, I'll buy. Neither Ahmad or Jane knew that that computer had already been destroyed and does not exist at the time of contract. Now, of course, at this juncture, you could be slightly confused and you may be wondering, how is it possible that we have part C and part D both to be discussing the same type of mistake? Now, this might not be that common, but it does happen, and it is not an overlapping discussion in terms of the relevant case laws that you'll be discussing when you begin this answer proper, because if you look at part C, it's a case of where the subject matter, the computer, never existed. Part D is where the computer existed, but later was destroyed. So you do realize that part C and part D is different. No doubt, for both part C and part D, in both cases, the computer did not exist at the time of sale. But the difference is that in part C, the computer had never existed at all. For part D, the computer existed but was subsequently destroyed. And so in your answer, you will be discussing different principles, different arguments, but both within bilateral, common mistake as to existence of subject matter of the contract. The last one. Both Ahmad and Jane think that Ahmad's only computer has the latest Pentium 10 processor. And when you see the word both, straight away you know it's bilateral. They're both mistaken. What were they mistaken about? They're both mistaken, thinking that Ahmad's only computer has the latest Pentium 10 processor, when in fact it has a much less powerful Pentium 6 processor. So they're mistaken. Both, it's bilateral. But is it as to existence? Now, it might be because you argue that in truth, the computer does not exist. But that's not a very accurate assessment. The computer exists. You said they were mistaken as to it being Pentium 10 or 6. That's right. This is more of a bilateral mistake as to quality of subject matter. Now, clearly, it's nothing to do with ownership. Okay? Now, it's not a mutual mistake either, because mutual mistake refers to where they are respectively mistaken as to different things. But here, for part E, they are both mistaken as to the same thing. That's why it's common mistake, as opposed to mutual mistake. So in closing, the difference between bilateral mutual and bilateral common, which I hope that you see now, is that for bilateral mutual, they are both mistaken as to different things. I want to sell you a desktop, you want to buy my laptop. There's no meeting of minds, and therefore the contract is void. In the case of Part E, they are both mistaken, but as to the same thing. They are both mistaken thinking that this is a Pentium 10 processor computer, but it's not. And therefore, because they're mistaken as to the same thing, it's a mistake that's common to both. It comes under bilateral common mistake. And it's a mistake as to quality, i.e. the Pentium 6 and 10 quality. They are both mistaken too. So with that, you have now identified all the types of mistake. And with that, you should be able to now write the relevant answer to come to conclusion by using the appropriate cases and the legal principles within each type of mistake, and to advise whether or not advise Ahmad in each of the following circumstances, whether would these all amount to operative legal mistake for the purposes of the contract being void. Perhaps, perhaps not. And that's what you can discuss on your own. It may be that in a separate session, I may record an answer on this. But otherwise, I hope that you found this video useful for purposes of giving you an idea of how a mistake question could be tested in an exams, and in particular to appreciate that mistake makes a contract void, and how there are different types of mistakes, whether it could be made by one or two parties, unilateral or bilateral. And within both types, you have even different specific types of unilateral, bilateral. Do you find this video enjoyable or useful, and perhaps you would like to have more of such videos, do feel free to click the link to subscribe and to like. With that, thank you very much.